Hi everyone, I am Srikanth. Today I just want to give you a brief on the topic of judiciary. Let's discuss judiciary in India. If we keep at the topic, we can find in primarily two stages. One is pre-independence and one is since independence. In pre-independence era, if we see the first legislation by the British, that is by the company, that is what we are know regulating act 1773. This is the first step that has been taken by the company to make some judicial aspects of the British in India. Through this act, what was established was the Supreme Court at Calcutta. The Supreme Court at Kolkata. But the one interesting thing is that this Supreme Court, which was established by this act, was only for the company. That means this court will be tried only for the British employees rather than Indians. Then what is for the Indians? For Indians, we already have our own native codes. They were called as Sadar Diwani Adalat and Sadar Nizamat Adalat. Diwani Adalat will treat the case of civil nature, whereas Nizamat Adalat will treat the case of criminal nature. These were two courts which should be at the state level, or I would say provincial level. These are the courts which were already established in Indian society, and they take case of for the only Indians. And whereas the Supreme Court at Kolkata, which was formed in 1773 Regulating Act, was only for the Britishers. After that, what? This is at the state level. Then at the district level, we have Mufuzil Diwani Adalat as well as Mufuzil Nizamat Adalat. Diwani is for the civil, the same way, as well as Nizamat, if you see this word, it is for the criminal. But this court will be at the district level, whereas the Sadar is for the state level. Clear? After this, one more interesting and important initiative, or I would say legislation, was the Government of India Act 1935. And we all know the importance of Government of India Act 1935 in changing the history of the Indian parliament system as well as Indian political system. In the same way, even the Indian judiciary was also has a great influence from the Government of India Act 1935. What is its importance? Government of India Act 1935. From this, the very important thing is the establishment of federal court. Federal court. Whenever you see the word federal, it means a court which should deal with the cases between the different political units. That is here between center as well as states. The word federal has been came from the word of feudus, which means an agreement between different political units. And here this establishment of the federal court, which means the Supreme Court, which is the predecessor of the current Supreme Court, where it's having a jurisdiction of dealing the case between the center and states. It is a primary jurisdiction. And secondary is it has the federal court is also have the jurisdiction of taking the appeals from the below courts. From the below courts. And what do you think are the below courts? Those were high courts. And when do you think high courts got been established in India? High courts in India has been formed from the Indian High Courts Act of 1861. Through this act in India, we got the high courts for the three important seaport cities. That is where the Bombay, Bengal and Madras, as we have expected, has been found. Along with the one more important thing is that along with this act, it also got removed or it also got the reinstated the high courts and removed the supreme courts, which have already formed in the 1773 regulating act. This federal court will take the appeals from high court in what matters? In civil as well as criminal matters. As well as criminal matters. And is there any court which is above the federal court? Yes, it is. But it is not a court. Then what? It is a council called as Privy Council. These are the British Parliament. Are also called as His Majesty's Council. Are also called as His Majesty's Council. This will be at the British Parliament in their own country, where they will take cases appeals from the Indian courts or any other colonial courts. This is the structure before the independence. Then what about since independence? Just after the independence, India has got its own constitution. Its own constitution, we have found our own Supreme Court. We will see in the constitution. Since independence, Constitution of India or constitutional makers have included the various aspects of judiciary, that is the formation of Supreme Court, High Court as well as subordinate courts. Regarding the Supreme Court, it was mentioned in the part 5, that is Union Executive from Articles 124 to 147. And number the second, that is High Court. High Courts were for the provincial level. High Courts were included in the part 6, that is the State Executive, where the articles is around 214 to 231. For subordinate courts, the articles has been in the it is from the same 6th part. Articles from the 233 to 237. These are the primary constitutional articles as well as parts from where the judiciary in India has been taking its powers from. Number 1 is Supreme Court, number 2 is High Court, number 3 is subordinate courts. Subordinate courts include the district courts, and whereas in the district level we have the various level different courts, that is the civil courts as well as the criminal courts, and we will see those structures as well in the later part. At first we will see the Supreme Court. What is Supreme Court? Supreme Court is nothing but it is only a predecessor. It is only a predecessor of the federal court, which already got established in the Government of India Act 1935. What about Indian judiciary? Indian judiciary, you can see it is, I would say, independent as well as integrated. Integrated. What do you mean by that? Independent means the judiciary is independent. That is, if you see in India, we are following a principle called as separation of powers. On that basis, the judiciary is having been given the independence as well as it was also given a very much important responsible role, that is to protect the Indian Constitution. So it must have been should be given the independence from the executive. And number 2 is integrated. What do you mean by integrated? It means you have to compare. It means number 1 is we have to compare with the other Western country, that is primarily USA. In USA, it is the federal government where we have different courts, that is Supreme Court and High Court and district courts. Whereas the Supreme Court will deal only with the case of federal nature, that is only with the case of union level, where the High Court will deal only with the state laws and district court will follow the High Court. Whereas for India, it is not, it is unlike that. For India, if you see, it is integrated. That means the High Courts will take the case of union laws and the Supreme Court can take the case of High Court. That means the state laws. It won't matter. It doesn't matter actually. That is why we say it is integrated. And as well as that, we already have seen the powers of federal court. That is the appealing powers. That is the appealing powers. That means you can approach the High Court, and if you didn't get satisfied with the judgment, you can again appeal to the Supreme Court. That means the Supreme Court and High Court and district courts, they are all in one single line. They are all integrated. This is the primary feature of Indian judiciary. Let's go back to the Supreme Court. Supreme Court in India has been established with the Articles of 124. It extends from 124 to 147. In Article 124, it shows that there has to be a Supreme Court in Delhi. The seat, when you mention the seat of Supreme Court, it talks about Article 130. It is of different matter. We will read it later. First 124. It talks about 124 of 2. Talks about the appointment of judiciary in Supreme Court. 124 of 2, which says that the President of India, he has to appoint the Supreme Court judges on the basis of what? On the basis of consultation with the other judges as he deems necessary. That means whoever, if he wants to discuss, he can discuss with them, and then he can take his decision of appointing any judges in the Supreme Court. That is what given in the 124 of 2 article. And if you see the word consultation, this has been a debate. What is this consultation? Does that mean that the President of India can just consult and can he take his own decision, or is it very much required that the consultation should be concurrent? That the opinion given by the judges, is it binding on the President of India or not? This is the primary area of conflict. Clear? And this primary area of conflict has been also dragged to the Supreme Court again. This is, you can evident in the first judge's case. What is this first judge's case? If you ask me, I would say the same issue, that the same area of conflict, that is whether the consultation is equal to concurrence, yes or no. This debate has been dragged in the first judge's case. The original case name is S.P. Gupta versus Union of India, 1982. In this case, the Supreme Court said that consultation is not equal to concurrence. That means the Supreme Court, whatever it has given the advice to the President of India, on the purpose of appointing the judges is not required to be binding. That means it is not binding on the president. That means the judicial primacy has been lowered. That means the executive has got the primacy. That means the president can appoint anyone as judges of Supreme Court plus CJA with whoever if he want he can take advice, and he is not required to follow the advice. This is the primary judgment in the first judges, that is SP 2000 Union of India 1982. This is very important in the evolution of the system of collision. In the second judges case, second judges case, the case is Supreme Court Advocates on Record Association versus Union of India 1992. So what is this case? If you ask me, I would say that this is the case where the Supreme Court has understood the mistake what it had did in the first judge's case, that is by giving the primacy to the executive, and here we try to rectify it by taking back whatever it has given. That is, in this case, the Supreme Court said that, brother, consultation is not equal to concurrence. It is not. That means consultation is equal to concurrence here. That means whoever, if you try to consult, the consultation, whatever the advice given by the court or judges is binding on the president. Binding on the president is what the judgment has been given in the second judge's case. That means not only the advice, not only the judges, which are the judges, that also has been given by the Supreme Court. It said that the President of India has to consult the Chief Justice, that is the senior most, plus two senior most judges of Supreme Court. That is, this is the judgment where it has given to the rise of the collegium system. CJI plus 2 senior most is equal to collegium system. What we are following right now, the birth of collegium system has been taken in the second judge's case, that is in 1992. Clear till now? What's happening? The judges have been deciding on what is the real thing, and they try to take away whatever the mistake that they have did in the first judge's case. That is in the second judge's case, the judges said that whether the consultation is equal to concurrence, and you have to depend on what we have suggested. That means the executive primacy has been lowered, and the courts and the judiciary primacy has been upward. Clear? Next, the third judge's case. Actually, the third judge's case is not a case. Then what's it? The third judge's case is not a case. Then it is the application of 143. What is 143 of judiciary? 143 says that the President of India at any time, if he wants to clarify any matter of any law, then he can ask the judiciary to give a brief on that specific matter of law. That means the President of India, he can take suggestion, he can take advice from the court, the Supreme Court, on any matter of law. On any matter of law. By using this power, then the President of India, Mr. K.R. Narayanan, he asked the Supreme Court in 1998. He asked the Supreme Court regarding he want to be given a clarity on the what is collegium system and what are the issues, and he want a solution. On this basis, the Supreme Court, in this case, the third judge's case, 1998, on this question, the Supreme Court has given its answer. What is its answer, sir? It said that President of India, please understand this. What we want to suggest is that we want to make some reforms. On that part, we want to expand the system of collegium. That is earlier, in the second test case, we said that CJI plus 2. But right now, we want to expand it. How? CJI plus 4 senior most judges would be there for selecting the courts of, for selecting the judges of the Supreme Court. Clear? That means there is nothing changed. The only change is that it has expanded the number of senior most judges in the collegium. That means again it is following the consultation is equal to concurrence. That is the advice is binding on the President of India. Clear? This is the right now what we are following the collegium system. This is the evolved collegium system. According to this, first the President of India will ask the collegium. Collegium will give their advice, a list of candidates. After this, it will go to the Ministry of Law and Justice. After that, it will go to the President of India. He will appoint. Okay, this is the process. This is the procedure of appointment of judges of Supreme Court as well as High Court. But there is only one small modification regarding the High Court judges. This is for the Supreme Court judges. For regarding the High Court judges, the collegium is the High Court judges. The collegium is the CJI plus 2 senior most judges, and not 4. There is one difference between the Supreme Court judges appointment as well as the High Court judges appointment. Nothing is different. Clear? Yeah. This is the very much important thing. That is the third test case. After this, there is a recent element in the 4 judges case. Actually, this is not a case. Just listen. In the 4 judges case, that is what happened in 2015. The story is that the government of India, it want to make some changes to the procedure of appointment of judiciary. Further, it made some 99th constitutional amendment. Through this amendment, it made a body called as NJAC, that is National Judicial Appointments Commission. What is this body, sir? This body is the ultimate body in the country which will make the appointments for the judiciary in the Supreme Court as well as the High Court. This is the body. And who will compose in this body? The composition is that it will have total 6 members. One is CJA, you can expect. Number 2, number 3 are 2 senior most judges of Supreme Court. There were 3 members. Then what? Then Ministry of Law and Justice in the union level. Then other 2 persons were eminent persons from civil society. There are 2 people, 1, 2, 1. Total 6 members belong to this committee, and these 6 members will give the list of recommendation to the appointment of the judges of Supreme Court as well as High Court. But what happened? Before this body even came into practice, the Supreme Court has made this amendment as null and void. Why? Because the Supreme Court has said that in the case, it said that the judicial supremacy, or I would say the judicial independence, is very key to the India's constitution. And it said that by using the theory of basic structure doctrine, it's applying here. It is saying that the judicial independence is also an element in the basic structure doctrine. So on that basis, if you are trying to reduce the judicial independence by involving the executive here, by involving the executive as well as these people, the outsiders, in the appointment of judiciary, that means it is a violation of the basic structure of constitution because they are violating the judicial independence. Clear? This is the key element. And one more thing is that there is also a veto power in the NJSC. What is veto power? And you know what is veto power? Veto power is a power which if you use, you can completely remove the decision taken in the committee. And here the veto power was given to at least two members. At least two members, if they want to, if they did not like any decision made in the committee, then they can veto it. That means the decision can be removed. That means if even this person, if these two persons also, if they want to remove the decision of CJI, then they can remove it by just using the veto power. This is how even the judicial privacy can be removed or can be suppressed, surpassed by the giving the veto power to these other persons who are cabinet professionals plus the executive. This is what the judiciary felt that there is a threat to its independence. That's how it removed the 99th Constitutional Amendment by making it null and void. So right now what we are following is nothing but the collegium system, and there are also many limitations in the collegium system, and we will discuss in the next class. Thank you.